morning, everyone. I'd like to begin this webinar today by acknowledging the traditional custodians on whose lands the Australian National University sits, and from whose lands I'm speaking to you today, the Ngunnawal and Ngambri people, as well as the traditional custodians on the lands on which each of you live, work, and learn. The First Nations people of Australia have had an intimate relationship with this landscape for thousands of years. They have met on country to learn and to share knowledge, to talk and to listen, and to discuss ideas and solve problems. And they've used that knowledge and those ideas to care for the country and to practice law thousands of years before the systems of international law that we'll be talking about today were developed. Just as we discuss rights and obligations and relationships, we acknowledge these same concepts: legal rights, legal obligations, and legal relationships governing community and land have long been practiced by our First Nations people. As we come together today, I'd like to pay my respects to the elders of this country, past and present, and to the culture, knowledge, kinship, and connection that they hold in relation to country. My name is Imogen Saunders, and I'm the Director of the Centre for International and Public Law here at the Australian National University. I'm delighted to welcome you today to this panel discussion on the Genocide Convention and the International Court of Justice. We are joined by three marvellous panellists. First speaking will be Associate Professor Melanie O'Brien, who is President of the International Association of Genocide Scholars and currently Visiting Professor at the Centre for Holocaust and Genocide Studies at the University of Minnesota. Second speaking is Professor Bill Campbell, KC, who has been General Counsel in International Law and Head of the Office of International Law at the Attorney General's Department. In these roles, Bill appeared for Australia in many cases, including before the International Court of Justice. We will also have commentary from Professor Donald Rothwell, a Professor of International Law here at the ANU College of Law. We are speaking today about a very contemporary and fast-moving area of international law. New events are unfolding on a weekly, if not daily, basis. Indeed, overnight we saw the first successful adoption of the UN Security Council resolution calling for a ceasefire in Gaza, with the US choosing not to exercise its veto power. Our focus today is the International Court of Justice cases around the Genocide Convention, but of course they are part and situated in the wider conflicts occurring around the globe. We're very fortunate to have such expertise from our three panellists today, and we will have time for questions at the end from the audience. Before I hand over to Mel, I just have a few words of housekeeping. As attendees to this webinar, your video and microphones are automatically turned off. This will keep the sound quality clear. Because of this, if you do need or do wish to ask a question, please use the Q&A or chat function at the bottom of the screen. You can ask questions anytime throughout the session, but we will come to them at the end and have time for them then. If you do have any questions or technical issues, please email marketing.law@anu.edu.au and the team will try and assist you. And finally, we are recording the webinar today. If you don't want your name to be recorded and you do want to ask a question, there is an option of using an anonymous function to ask that question, or you can message the host who will convey that message to me to ask. So with all that said, I would like to welcome you again to this session and hand over to Mel, who will begin the webinar.
Thank you so much, Imogen. And as Imogen has said, this is definitely an evolving topic. I think I've been speaking on this almost on a weekly basis and have to change my presentation content as it goes along. I'd really like to thank ANU for inviting me to participate today, even though I'm out of the country. And on that note, I would like to note that I am currently speaking to you on the traditional, ancestral and contemporary lands of Minnesota, Makoche, the homelands of the Dakota Oyate Indigenous people, where I currently live and work at the University of Minnesota. So the Genocide Convention, which has been around for 75 years, contains a few relevant provisions for the purposes of our discussion today. The focus being that state parties' obligation is to prevent and punish the crime of genocide, Also that persons charged with genocide shall be tried by domestic or international criminal courts, but in particular, Article 9, which is the compromissory clause of the Genocide Convention, which says that disputes over the Genocide Convention shall be submitted to the International Court of Justice. So this is the provision by which we see cases brought before the ICJ. Now, its 75 years of life have actually not seen until recently very many cases. In fact, there have only been 6 contentious cases under the Genocide Convention before the ICJ, and there was one advisory opinion back in 1951 about reservations to the Genocide Convention, which, on a side note, it deemed permissible as long as they are in accordance with the purposes of the convention. I am not, because of time and our focus today, I'm not going to talk about the 2 completed cases, which are Bosnia v Serbia and Croatia v Serbia. But if anyone has any questions about those, I'm happy to talk about those in Q&A. What I want to focus on are the current cases before the ICJ, because this is quite amazing that we had only had 2 cases in the whole 75 years of the Genocide Convention, and suddenly we have 4 ongoing at the moment. Now, I'm going to walk you through what's going on with these, but I'm not going to cover the provisional measures because Bill is going to cover those. So all I will do is merely mention that there are provisional measures, and Bill will go into detail about that aspect of the cases. The first case is the Gambia v Myanmar, and this was started in November 2019 when the Gambia instituted proceedings claiming that Myanmar is in violation of its obligations under the Genocide Convention with regards to the Rohingya people. It also requested preliminary measures, which, as I said, Bill will talk about. Now, that case is a little more further developed than the other cases. In July 2022, they actually had the judgment on the preliminary objections, and the short version of that one is that the ICJ held that it has jurisdiction and that this case will proceed to the merits phase of proceedings. So what is interesting about this case, of course, is that this wasn't a case of a state that was directly affected by genocide bringing the case. Obviously, the Gambia isn't the territory where the Rohingya are and wasn't affected. But this was something that the court said that the Gambia could do. And so this was confirmation that any state that is a party to the Genocide Convention can bring a case against another state under the convention because of the erga omnes obligations under the Genocide Convention and every state's interest in upholding that duty to prevent and punish genocide. Now, in the Gambia v Myanmar case in November last year, we saw 7 state interventions in the case, and these came from the Maldives, Canada, Denmark, France, Germany, the Netherlands, and UK. And I'll come back to interventions momentarily. The next case that we've got going on is Ukraine v Russia. And Ukraine brought this case only a couple of days after Russia invaded Ukraine in February 2022. And this, again, is a completely different case and really quite interesting in its content, because instead of alleging that Russia is committing genocide, instead, Ukraine was claiming that Russia's justification for invasion being the prevention of genocide in Ukraine, claiming an ongoing genocide taking place in Ukraine, was false. And by doing so, Ukraine is not performing its duties to prevent genocide under the Genocide Convention in good faith. So their argument was that this duty under the convention must be performed in good faith and not abused. They argued that one party must not subject another party to the convention to an unlawful action based on a wholly unsubstantiated claim of preventing and punishing genocide. And by doing that, their main claim was that Russia is undermining the object and purpose of the Genocide Convention. And of course, we all know that object and purpose of a treaty is really key when we're talking about interpretation and application of the treaty. So the Ukraine asked ICJ to declare that, firstly, no genocide occurred in Ukraine and that Russia cannot take action from this false claim, that Russia's invasion has no basis in the Genocide Convention. They asked for assurances of non-repetition and full reparation for damages caused. There were preliminary measures ordered, which Bill will cover. But also what happened in this case that was quite unprecedented was the number of interventions in September 2022. 32 states intervened to support Ukraine. And this is quite a phenomenal number. It did include most of the countries that have since intervened in Gambia and Myanmar, except for the Maldives, but listed quite a number of countries, including Australia and New Zealand. So that is really interesting. And essentially, they intervened to support Ukraine, although, of course, legally an intervention isn't in support of one side or the other. It is simply about their own interests in the dispute under the treaty rather than taking one side. But of course, they have all indicated their support for Ukraine. We have since recently had the preliminary objections ruling, under which the court said, yes, there is a dispute under the convention, but it dismissed Russia's procedural objections. Essentially, what the ICJ has held in this case is that it cannot adjudicate on Russia's use of force, because even though that use of force might be a violation of international law, it's not a rule that falls under the Genocide Convention, even if Russia is justifying its use of force as genocide prevention. In other words, its obligation under the Genocide Convention. But what the ICJ said was that it can rule on whether or not Ukraine has violated the Genocide Convention by committing genocide, as claimed by Russia and denied by Ukraine. So essentially, this is the request of Ukraine wanting the court to say that it has not committed genocide. And this is now going to be the only component of the merits phase of this case. I think this is disappointing because essentially Ukraine's argument was about upholding a treaty, upholding the object and purposes of a treaty and applying a treaty in good faith, rather than actually ruling on the legality of the use of force. And in my opinion, that's where the court should have gone with this preliminary objections ruling. Our next case, and not even our most recent case, only brought before the court in December 2023, which is astounding that it's not even our most recent case. South Africa instituted proceedings against Israel, claiming that Israel is in breach of obligations to prevent and punish genocide and incitement to genocide in particular, with regards to Palestinians in Gaza. Again, there's been requests for provisional measures and provisional measures ordered, which Bill will go into. And this one is a particularly complex one with several different requests for provisional measures. Now, in this case, we have seen the indication of potential interventions, possibly in the future from Germany, perhaps Bangladesh, maybe even Palestine. But so far already, there has been an intervention application from Nicaragua, which took place in January of this year. Which brings me to the most recent case, which was brought by Nicaragua on the 1st of March. So only this month, Nicaragua instituted proceedings against Germany this time. And again, this is in relation to Palestinians, particularly in Gaza. So Nicaragua has brought several claims under this. They're not only related to the Genocide Convention, so I'll just go through all of those main claims. So they have brought the genocide claims under Article 9 of the Genocide Convention. They're claiming that Germany provides political, military, and financial support to Israel with the awareness that the equipment, the financing, and any other support that they're providing is enabling Israel to perpetrate genocide and other atrocities. They are also arguing that by Germany cutting off funding to UNRWA, this is jeopardizing the effective assistance to Palestinian refugees, which in itself is facilitating the commission of serious breaches of international law. They're arguing that Germany is in breach of its obligations to prevent genocide with regards to Palestinians. So those are arguments related to, that it's brought related to genocide and international law generally, but it has also drawn on international humanitarian law, and as it frequently mentions, without being very specific in its application, peremptory norms of international law. So it's arguing that Germany has failed to comply with international humanitarian law, in particular the Geneva Convention, specifically the Fourth Geneva Convention, the additional protocols and customary international law. It's also arguing Germany's failure to comply with peremptory norms of international law by assisting the maintenance of the illegal occupation of Palestine, including unlawful attacks on Gaza, and assisting and not preventing the apartheid regime and the negation of the right to self-determination of Palestinian people. So Nicaragua has brought the second part of this that isn't related to the Genocide Convention under the declarations that both Nicaragua and Germany have made under Article 36(2) of the ICJ statute, under which they have agreed to the compulsory jurisdiction of the ICJ. So this is the only way that they could do this, because actually the Geneva Conventions and additional protocols do not have compromissory clauses. So this is the only way that IHL cases can be brought to the ICJ. Nicaragua has done this before. It used this method for bringing claims under IHL. Of course, we all know the famous Nicaragua case that it brought against the USA using the same method. So Nicaragua has requested provisional measures in this. Obviously, it is very recent, and so there's a hearing set for those provisional measures for the 8th to 9th of April. So only in a couple of weeks, actually. So that is in a nutshell where we're at the moment with the current ICJ cases, and I am now going to, it's going to be handed over to Bill, who's going to go into detail about the provisional measures orders that relate to these cases.
Thank you very much, Mel. And as foreshadowed, I will hand over to Bill to continue with the presentations.
Thank you, and thanks to Sybil for inviting me to participate in the seminar. And I'd also like to pay my respects to the Ngunnawal people on whose lands we meet. Now, each of the applications commencing the current ICJ cases dealing with genocide was accompanied by an application for provisional measures, these being the international law equivalent of an interim injunction in domestic court proceedings. And Article 74 of the ICJ rules provides that such requests have priority over all other cases. I'll begin with an outline of the purpose of provisional measures and the requirements underpinning their grant, and I'll then critique aspects of the provisional measures sought and given in the current genocide cases before the ICJ and how those measures might be enforced. Now, the court in the Certain Documents and Data case brought by Timor-Leste against Australia held that the power of the court to indicate provisional measures under Article 41 of the statute has as its object the preservation of the respective rights claimed by the parties pending the decision on the merits. A party may seek interim measures at any stage of the proceedings, and such measures may be sought multiple times, as the South Africa-Israel case demonstrates. And the court must satisfy itself of 4 matters before indicating provisional measures. The first is that the jurisdictional provisions relied upon by the applicant appear prima facie to afford a basis for the jurisdiction of the court. Secondly, the court must satisfy itself that the rights which a party is seeking to protect in the proceedings are at least plausible. That is, there is a realistic prospect that when the court rules on the merits, those rights will be found to exist and be applicable. Thirdly, a link must exist between the right protected and the measures ordered. That is, the provisional measures must be aimed at protecting rights which the court has found to be plausible. And fourthly, there must be urgency. That is, a real and imminent risk that unless measures are ordered, irreparable prejudice will be caused to the rights in dispute prior to the court giving its final decision on the merits. Now, just to close the loop on a couple of matters, first, the court has confirmed, most recently in the South Africa-Israel case, that provisional measures orders have binding effect and thus create international obligations. And secondly, provisional measures lapse on the final judgment or if the court otherwise terminates them. Under Article 76 of the rules, provisional measures may be revoked or modified by the court either of its own volition or at the request of a party if circumstances have changed. Now, in the time available, it's not possible to set out all the provisional measures ordered in the recent genocide cases, so I'll just summarise them. In the Gambia-Myanmar case, the court ordered Myanmar to take all measures within its power to prevent the commission of genocide against the Rohingya and to preserve evidence related to allegations of genocide. In the Ukraine-Russia case, the court ordered Russia to suspend all military operations in Ukraine and to ensure the persons under its control take no further steps in furtherance of the military operations. Now, there is a question as to whether that remains in force following the court's decision on preliminary objections. In the South Africa-Israel case, the court ordered Israel, in relation to the Palestinians in Gaza, to take all measures within its power to prevent the commission of genocide, to prevent and punish incitement to commit genocide, and to enable the provision of basic services of humanitarian assistance. It was also ordered to preserve evidence. In Nicaragua and Germany, Nicaragua has sought a wide range of provisional measures, including suspension of German military assistance to Israel and reversal of Germany's decision to suspend funding to the United Nations Relief and Works Agency, known as UNRWA. So have the measures ordered so far in these cases been effective? Well, from what is known publicly, I'd conclude that they have not been effective in stopping the conduct which is the subject of the measures. Myanmar continues to act against the Rohingya. Russia's armed intervention in Ukraine also continues. And to me, it seems to be clear that Israel is not complying with various aspects of the provisional measures order made by the court. Just one example being its obligation to take effective measures to provide basic services and humanitarian assistance. As I noted earlier, the ICJ has confirmed that provisional measures are binding as a matter of international law, and that those binding obligations are independent of the plausible obligations that they are seeking to protect. So if they are binding obligations, how could they be enforced? One possibility would be for the applicant state to refer non-compliance to the Security Council under Article 94(2) of the UN Charter, with a view to the Security Council taking measures to give effect to the judgment of the court. Now, leaving aside that an order of interim measures is probably not a judgment within the meaning of 94(2), any proposed action by the Security Council, I think, would almost inevitably be the subject of a veto by one or more of the permanent members, but I'm not so sure after last night. Another, I would say, remote possibility raised by Matei Alexianu in Eagle Talk recently is the taking of countermeasures by third states against the respondent state for its failure to comply with provisional measures ordered by the court. Countermeasures of their very nature involve taking actions which would otherwise be unlawful against the respondent state for its failure to give effect to a provisional measure. Alexianu himself mentions possible legal impediments to countermeasures as a means of enforcement, where the state seeking to impose the countermeasure has not been directly affected by the applicant's state's failure to comply. Now, that said, the actions by third states against the Russian Federation response to its continuing force in Ukraine, including trade measures such as restricting the supply of aircraft parts to Russia, might be characterized as countermeasures. While the court itself is not in a position to take effective enforcement action, it can note a failure to give effect to the provisional measures in its final judgment. For example, in the Bosnia-Serbia genocide case, the court included in the operative clause of its judgment, by way of satisfaction, a declaration that Serbia had failed to comply with the court's orders indicating provisional measures. Also, the court will on occasion criticise a state's failure to comply. For example, in response to South Africa's first request for additional provisional measures, the court, through a press release issued by the registrar in February, impliedly criticised Israel for not implementing the provisional measures the court had already ordered. Now, the court's practice in responding to failures to comply hasn't been consistent. In the Ukraine-Russia case, the court, in dealing with preliminary objections, went through all the claims but one. It studiously avoided commenting on the request in Ukraine's memorial that Russia be found in breach of the provisional measure relating to the suspension of military operations. Sorry. All this is not to say that the seeking or ordering provisional measures in the recent genocide cases are without purpose. An application for provisional measures brings an immediacy to the case that enables the issues before the court to be aired at an early stage. Indeed, given the current dire circumstances sought to be litigated in each of the cases, the applicant states, in my view, had little choice but to seek provisional measures. Also, the court has utilised its consideration of provisional measures to express concern over the situation it is confronted with, and those expressions of concern go beyond the legal parameters of the dispute before it. Mark Latimer recently has referred to this as the symbolic realm and as the greatest impact of provisional measures in the genocide cases. For example, the court in its order in the South Africa-Israel case expressed its deep concern over the continuing loss of human life and suffering. And those expressions of concern are picked up by the United Nations and other states to place pressure on Israel and Hamas to end hostilities. The content of the orders able to be made by the court is limited by the extent of its jurisdiction and the plausible rights it is seeking to protect. In the South Africa-Israel case, Judge Nolte noted that the court could only play a limited role, being confined to alleged violations of the Genocide Convention by Israel. He noted further that the case does not involve violations of the rules of international law, such as war crimes, and does not concern possible violations of the Genocide Convention by persons associated with Hamas. And he stated, quote, "While these limitations are unsatisfactory, the court is bound to respect them." And those considerations help explain the content of the interim measures ordered by the court in that case. The court's made clear in the 3 recent genocide provisional measures cases that it's not confined to ordering the measures sought by the applicant. Indeed, it departed from the measures sought in those cases in a number of ways. For example, for the reasons stated by Judge Nolte, it did not, as South Africa had sought, order that Israel, quote, immediately suspend its military operations in and against Gaza, unquote. Yet in its second application for the indication of additional provisional measures of 6 March 2024, which is yet to be dealt with by the court, South Africa has asked the court to order that all participants in the conflict must ensure that all fighting and hostilities comes to an immediate halt and that all hostages or detainees are released immediately. Such an order would again extend beyond the rights based on the Genocide Convention, and for that reason is unlikely to be made by the court. Also, in its terminology, the proposed order applied to Hamas as well as Israel, even though Hamas is not a party to the case. Of course, much of the content of the additional provisional measures sought by South Africa is picked up in the Security Council Resolution 2728, adopted by the Security Council overnight. So thank you very much.
Thank you very much, Bill. I'm now going to hand the floor over to Don Rothwell, who will comment on the fantastic presentations from Mel and Bill.
Thank you, Imogen. I'm principally going to build upon the material that Bill Campbell's just been referring to. But before I do so, I just want to make an observation about Nicaragua's intervention in these matters. For an audience predominantly based in Australia, there might be some surprise about Nicaragua's engagement in these cases before the International Court of Justice. But Mel O'Brien, of course, properly referenced the fact that one of the most significant international law cases is the case that we know as the Nicaragua case brought against the United States. It's actually quite interesting to note that whilst the United States, according to the ICJ website, has been involved in 25 cases before the court, Nicaragua, the United Kingdom, and France have all been involved in 16 cases. So they are the next group of states who have been involved in the greatest number as applicants or respondents. And as Bill Campbell well knows, from a law of the sea perspective, Nicaragua's cases with respect to the law of the sea in the Caribbean have been particularly significant. And so I think I would just generally make the point that Nicaragua is actually quite an experienced litigant before the International Court and has quite an experienced team of counsel who would be involved in preparing the request for the case against Germany and also for its intervention in the South Africa-Israel case. Now, I guess one of the perhaps extraordinary aspects of the South Africa-Israel case is that the court, of course, ordered provisional measures on the 26th of January. But since then, as Bill Campbell alluded to, South Africa has made 2 additional requests for additional provisional measures. The first one of those was made on the 12th of February and was responded to on the 16th of February. And the principal catalyst for that request was the announced Israeli Defense Force assault on Rafah. And to that end, the court was really placed in a situation where it had to deal with the South African application, the Israeli response, purely on the basis of written observations. The court dealt with that very expeditiously, but effectively just reinforced the original set of provisional measures issued on the 26th of January and emphasized that Israel remains fully bound to comply with its obligations as set out in the 26th January set of provisional measures. Now, since then, South Africa has gone back to the court on the second occasion, that was the 6th of March, seeking an additional set of provisional measures. And on this particular occasion, the provisional measures sought by South Africa are really framed around the dire humanitarian situation as presented by South Africa in Gaza. And Bill Campbell has alluded to some of the elements of that provisional measures request. So that request was made on the 6th of March. Israel, as is proper, made its written observations on the 15th of March. And yet here we are on the 26th of March in Canberra without a decision by the court. And so to that end, it's perhaps just useful to think about the speed with which the court has acted in the various aspects of the provisional measures requests. The original request, when South Africa commenced its proceedings before the court, which of course involved oral hearings in The Hague, was determined in 29 days. The first additional request that I referred to was determined in 4 days. And yet here we are 20 plus days since the second additional request, and we haven't had a determination by the court. Now, I think it would be remiss, Imogen, if I didn't make some observations with respect to the development overnight in the United Nations with respect to the Security Council resolution that was adopted, which seeks to address a number of relevant matters. And so I guess from my perspective, the key takeaways from Resolution 2728 adopted overnight in New York by a vote of 14 votes in favour with one abstention, the abstention being from the United States, is as follows. The first is that the resolution only has 2 operative paragraphs, and given the significance of this particular matter, that to my mind is a relatively short Security Council resolution. Secondly, the resolution calls for an immediate ceasefire, but the terminology of the resolution is such that it's only directed for the month of Ramadan. So there's a temporal limitation in terms of the ceasefire call by the Security Council. Secondly, the ceasefire clearly applies to both Israel and Hamas. It requires the release of the hostages. It emphasizes that humanitarian assistance should be provided, and I quote, demands for the lifting of all barriers. And that's clearly directed to Israel's Gaza blockade. 2 final observations I'd make about the Security Council resolution. One is that there's no reference to genocide or indeed to the decisions of the International Court of Justice in the South Africa-Israel case that we've been discussing. And secondly, that there's no language in Resolution 2728 which could be interpreted as impairing Israel's right of self-defense. And indeed, the text is silent on that particular point, other than calling for the ceasefire. I look forward to questions, Imogen. Thank you.
Thank you very much, Don, Mel and Bill. We do now have some time for questions. So I'd ask those attending, if you would like to ask a question of the panellists, to pop it in the Q&A, and then I'll be able to direct it their way. And I'll just give you all a little bit of time to do that. And while I'm waiting for those questions, perhaps I might kick off with one. And it sort of builds on what you were saying, Don, but also both Mel and Bill, in that one of the, I think, quite interesting things about the current actions in the ICJ is the role of the Global South. You know, we have the Gambia, who brought the case against Myanmar, South Africa, who brought the case against Israel, Nicaragua, obviously intervening and bringing the case against Germany, though, as Don said, Nicaragua is a frequent user of the ICJ. And Mel mentioned a possible intervention by Bangladesh in the South Africa case. So I guess I'd just ask either Mel or Bill, what do you think the significance is that it does seem to be Global South countries in some ways pushing the use of the court in this respect?
Firstly, generally, I think it's really great to see the convention being used. That's what it's there for. Some people are calling it lawfare, but my argument is that this is just using the law as it's intended to be used for, to call for accountability, and in this case, state responsibility for states who are in violation of their obligations. And, I think it's great that we've got states doing that, willing to do that. In the case of the Gambia, this is a small country that is geographically quite a long way away from Myanmar, but was willing to step in, which I think is pretty amazing. But at the same time, Gambia has quite a history of connection with international justice. They have contributed prosecutors to international courts and tribunals, like Hassan Jallow, for example, the ICTR. So that is a country with an already existing connection to enforcing international law and enforcing these exact kind of standards. We're talking about international crimes. And as you said, Nicaragua, frequent flyer, and South Africa, for them, it's a connection here. It's because of their connection with apartheid, and they have long talked about, they have with regards to having had their own apartheid in the past and the Palestinians experiencing that at present. So I feel like these states all have some kind of direct connection in some way to the legal process, or at least the experience of the victim group that they're bringing the cases against.
Imogen, if I could just add that it was sort of alluded to by Don. There's sort of a myth that the International Court is a place for developed countries, but in fact, less developed countries, and now called the Global South, utilise the court quite a lot and have done so for some time. I just wonder whether I could just raise something with Don about the resolution that was passed last night, as to whether, when I read it, like a lot of UN Security Council resolutions, I'm just a little uncertain under which chapter of the UN Charter it was actually adopted under. I mean, the word demand seems to indicate that it was adopted under Chapter 7 of the Charter, but I just wonder whether you have thoughts on that, Don.
Thanks, Bill. And indeed, I think it's notable that the resolution, as I've seen it, doesn't make clear the words that are common in this situation, where the Council would say acting under Chapter 7 of the Security Council of the United Nations Charter. And indeed, I'm understanding that the United States has put out a position that it doesn't believe that the resolution is legally binding, which I think would reinforce the fact that this may not be at least interpreted by the United States as a resolution adopted under Chapter 7, in specifically Article 41. So I noted that the resolution is relatively brief. It's obviously been drafted with some speed, but obviously some concessions needed to be met to get the vote that was actually achieved.
Thank you all. And I have a couple of questions from the audience. So I might start with this one from Karen Scott, because she's having to leave us very swiftly to go teach. Thanks, Karen. So her question is aimed at Don, but I think could be answered perhaps by Bill as well, and Mel if you want to. And it's about why Nicaragua brought the case against Germany and not any of the other states that might be supplying aid and or weapons to Israel. And Karen has said she supposes the US would not be an option, and of course US has got reservations to Article 9, the compromissory clause of the Genocide Convention. But why not any of the other countries, such as the UK or others that might also be liable in a similar way to Germany?
Thanks, Karen. Look, I can only speculate about this. I think that there was some analysis about the fact that Germany, for historical, political and diplomatic reasons, was certainly very supportive of Israel's response to the 7 October 2023 attacks, and has continued to be very supportive of Israel, and indeed perhaps even outspoken, it could be argued. So that would be the only observation I would make, in that Germany has been a strong supporter of Israel, but politically and symbolically, any state seeking to bring a case against Germany with respect to genocide is very powerful. But I'm sure Mel, as a genocide scholar, might have some thoughts on that too.
Yeah, I mean, it's an interesting question, isn't it? I mean, in terms of Nicaragua bringing the case, they didn't just bring it under the Genocide Convention. So they're also raising IHL issues, which they've done before with the United States. And I mean, is it a political decision? The US and Germany are the two biggest suppliers of weapons to Israel. So in that regard, US should be the equivalent. And I think everyone is asking that. I guess I'm not across at the moment the relationship between Nicaragua and the US, so I'm not sure what kind of political aspects might be at play there. As we know, there are always political elements to a decision to bring a case before the ICJ, and in this case, perhaps Nicaragua thinks that bringing a case against Germany won't have an impact on Nicaragua in the same way a case against the US might. That just a thought.
Could I say that I suspect that there might be more water to flow under the bridge in relation to this, because to take the case, for Nicaragua to take a case to the ICJ, it has to establish that there's a dispute between it and the country involved. So, you know, it may well be that Nicaragua takes more cases in the near future.
Thank you, Bill. So I suppose we'll all be following Nicaragua's public statements very closely in terms of what they're saying and which countries they're saying it about. I have another question that I might direct to Mel to answer in the first instance, from Kim Rubenstein. And Kim was just wondering how, instead of basing claims on the Genocide Convention, whether questions of crimes against humanity would be an option, and how those legal issues might play out before the ICJ on a basis of breach of crimes against humanity as opposed to the Genocide Convention.
Yeah, thanks, Kim. This is a really current question as well. I was in New York just the week before last, talking about the draft Crimes Against Humanity Treaty and discussing it with the Australian mission there. So one of the problems here is that there is no Crimes Against Humanity Treaty. So essentially, when we're talking about the ICJ, that's our starting point, that there isn't a treaty to bring anything under. And then secondly, you know, another option is obviously customary international law, but there is a debate as to whether crimes against humanity is customary international law or not. And one of the reasons of that is that even though the concept of crimes against humanity has existed since the post-World War II trials, the definition itself has changed significantly over essentially each draft that appeared. So, you know, the Nuremberg tribunals had one draft, and then the Nuremberg principles had another draft, and then the ILC's draft code on crimes against mankind had another definition. Then the ICTY had another definition. Some of the definitions had a connection with armed conflict. now the definition doesn't. So this has been part of the challenge with determining whether or not this concept of crimes against humanity is actually amounts to customary international law. So those are the barriers in terms of ICJ state accountability when it comes to the alternative of crimes against humanity. But I will certainly say that crimes against humanity are definitely an option when we're talking about individual criminal responsibility before the ICC, and obviously generally tend to be the category of crimes that is predominantly used because they are easier to prove than genocide when we're talking about individual criminal responsibility. You know, as we've seen through the ICTY, the extensive charges and convictions under crimes against humanity, and as we're seeing going through the International Criminal Court as well. So there is a push for a Crimes Against Humanity treaty undergoing. It is next week in New York. The Sixth Committee will meet again to move, hopefully, fingers crossed, hopefully move towards negotiations. So we're not even at negotiation stage yet for that treaty. It is under discussion. There is a draft that the ILC, the International Law Committee, has drawn up, and the Sixth Committee is discussing it. So it's kind of a watch this space kind of area. Australia is very much involved in supporting such a treaty and encouraging states to move to negotiations for such a treaty. And so I will say that the current version of the draft of the treaty includes a compromissory clause to allow for ICJ jurisdiction over disputes. So Kim, hopefully at some point in the future, this will be an option before the ICJ, but I guess that is, you know, quite a few years down the road.
Another question from Susan Grace is something that has actually, Mel, you alluded to earlier, but I'll open it to all three of you, is do you think that we're likely to see retaliation at a political level from the states that have been called out or challenged under the Genocide Convention to those states utilising it against them?
Bill looks reluctant to take this one.
I'm not reluctant. It's just that any answer that I give on it would, I think, be speculative. You know, I think further down the track, it might have an effect on relations between the countries, but as to whether they'd take any concrete form of retaliation, I think it would just be speculation to talk about that now. I suppose my major point is, yes, it could well affect relations, but as to specific retaliation, I just don't know. I tend to doubt it, but we'll see.
I would agree with that. I wouldn't really have anything to add.
I didn't mean to be reluctant.
I think, Imogen, the point that I would make is that it's interesting to observe that some states have sought to build and reflect upon these proceedings in significant diplomatic statements. And the 15 February joint statement by the Australian, New Zealand and Canadian Prime Ministers on the situation in Gaza, that statement being particularly predicated by the proposed Israeli Defence Force military operations in Rafah, is, I think, relevant because the three prime ministers and the three countries directly reference the provisional measures order of the International Court on 26 January. And I'll just quote, the prime ministers say, the International Court of Justice has been clear. Israel must ensure the delivery of basic services and essential humanitarian assistance and must protect civilians. The court's decisions on provisional measures are binding. So it's interesting to note that other states are clearly referencing the court's orders, no doubt diplomatically in their conversations with Israel and indeed other states, and no doubt with Russia, but also in their public observations.
Thank you all. We have time for one more question, and the question I'm going to ask draws on one from Julia Dean in the audience. And perhaps I'll just ask if you could elaborate a bit more on this interaction between the UN Security Council resolutions and the ICJ cases that we have ongoing, and what interaction or influence they might have on each other.
Well, perhaps I can pick up on a point made by Don before, and that is, I was a little surprised that the Security Council resolution that was passed or adopted last night didn't make reference to the decision or the preliminary objection, the provisional measures decision of the ICJ, or what the ICJ had said. But noting what Don said about how short the resolution was, one gets the impression that the resolution was so short, and perhaps the Security Council provisional measures, the ICJ was not mentioned because of the need to get the resolution passed. In other words, things were not put in if they were going to cause a problem. That's all.
Look, Imogen, if I can jump in and say that I think that this is a really fascinating area. And of course, the International Court has from time to time made observations about the relationship between itself and the Security Council. And indeed, the Lockerbie case is perhaps one of the most interesting of those cases. And I was reading this morning the dissenting opinion by Judge Veeramantri in Lockerbie, who directly addresses this issue of the relationship between the Security Council and the International Court, and the distinctive but complementary roles that they play. Given my observations about the fact that the court seems to have taken its time in responding to this second South African preliminary measures request, it'll be interesting now to see whether the court is incentivized to act given the decision of the Security Council overnight. And indeed, as Bill was outlining, the South African request actually aligns by and large with many aspects of what the Security Council has now determined, and in particular, the Security Council resolutions aspects in terms of a ceasefire. Of course, South Africa calls for a cessation of hostilities, but also for the provision of humanitarian aid. And those are essential aspects of the Security Council's Resolution 2728.
I think it's also, I wanted to pick up on the other part of Julia's question, asking about apart from the Security Council, where can this go? And a lot of people ask this because they talk about the fact that the provisional measures in these cases that we're talking about, as far as we know, have not been complied with. Significantly anyway, we do know only because Israel put it in its response to the latest provisional measures request, that Israel did submit to the court its report as required under the first provisional measures order on the 26th of February, but that has not been made public, the same way that any reports that possibly have been submitted by Myanmar under that provisional measures order have also not been made public. So we don't know if they've been submitted. But generally, someone did a study that they posted on EGIL Talk that worked out that more than 50% of provisional measures are complied with. And I think one of the things we need to remember is that international law exists because states agree to it and they see this system as important. They recognize that we do need a legal system that helps us with state relations and helps us to, well, hopefully maintain peace and security. I know it's not always successful, but it is also successful at other times. And those tend to be the times that we don't talk about. But also what we're seeing here is that when the court issues a provisional measures order and a state does not comply with it, then we can blatantly and publicly say that that state is in violation of international law. And that may be contrary to the message that is being delivered by that state. Israel is an example of that, because they continue to say that they comply with international law, but clearly now we know they are not, because they are not complying with the ICJ's provisional measures order. So even that in itself is significant in what we can do. But what also it can do is get other states thinking about their relations with Myanmar, with Israel, with Germany, with Russia, etc., and thinking about their risk of their engagement with that state. I mean, you know, the case against Germany really highlights that. And so there are other ways that there can be accountability. And, you know, of course, thinking about sanctions, even if the UN Security Council doesn't implement sanctions, individual states can do that themselves if they have legislation like Australia does. Australia has Magnitsky-style sanctions that it could implement on states, on individuals, on entities for human rights violations. So I think it's important to not have the sole focus being that the provisional measures, you know, will never get enforced by the Security Council, for example, but thinking about all of these other ways that those states will essentially possibly end up pariahs on the international stage, and how it will affect their relations, their international relations, their economic relations with other states as well, you know, with that knowledge that they are in violation of international law.
I think we have run 3 minutes over time. So I think we will leave it there, unless, Bill, did you want to say anything about that final point?
I just wanted to say that I wouldn't be surprised. I don't think the ICJ cannot order all of the additional provisional measures sought by South Africa, because they're so broad, and in fact, some of them are directed towards third states. But what they might do is pick up on the UN Security Council resolution and reinforce it from the court's perspective. Thanks.
Thank you. This has been a really important and fascinating webinar. There is, you know, we could keep talking for hours on this, but we are limited to the time scheduled. So I'll just thank everyone for coming, and thank very much Mel O'Brien, Bill Campbell, and Don Rothwell for your participation. Thank you, everyone.